So let's talk about reopening the economy, preparing yourselves to return your workers to the workplace. It's very important now, and we're going to go ahead and give you some good practice tips. So now, especially Illinois opening up right now is a big deal. So let's get started. So the first thing, we want to kind of talk about are just some initial thoughts. And that, the reopening plans across the country have been confusing. We don't have just one central place for this information, and we're getting it from different governments, if it be your local or your state. So we're going to try and give you some good business decisions to look at so that you can make sure that you're opening up safely for you and your employees and your customers and your vendors. There's no one size fits all here to opening up your business. So again, you might need to tailor these what's going to be best for your operation. The two most important things you're going to want to keep in mind when you're going through this process is to look at, obviously, the health, the welfare, and safety of everyone. Yourself, your employees, contractors, customers, suppliers, the public. That's one of our main, things that we want to do here. And then two, you want to have the ability to operate your business as effectively as possible. Many of you have been shut down, and you haven't been working for the last 2.5 months. So we want to be able to make sure you can open up and you can do it right and you can do it safely. So we're going to be identifying some local and state mandates and guidelines. Just remember that everything's changing. And again, like I said, not one size fits all. What you might be implementing in St. Louis, Missouri for your manufacturing plant is very different than what you're going to be implementing for your Chicago, Illinois corporate office or what your Atlanta, Georgia warehouse is doing. This is changing day to day, week to week, month to month. So just again, make sure that whatever you're going to be doing and when you're going to be doing it, you're going to be in compliance with your local government, the CDC, the Public Department of Health, things like that. Next slide, Emily. So we're going to discuss and cover, here's our agenda. We're going to look at the latest guidance from the governments on phasing in your workers. Screening employees is a big deal. The EEOC gave the blessing, so we're going to look at, temperature checks at the door, privacy concerns, protecting your employees and having the appropriate PPE available, requiring customers to wear PPE and things like that. We're going to talk about some public and transportation and commuting issues and some tips for that. Another big thing is childcare issues that your employees are going to be having. We're going to look at some guidance on, the childcare issues that employees are facing now that we can return to work, but maybe, daycares are not open and obviously schooling. We're going to give you some guidance on avoiding potential discrimination claims and pitfalls. We're going to give you the latest on OSHA. We're going to give you some great guidance on workers' compensation issues and claims and how to have the least risk there. And then managing some public relations. And we're going to give you a lot more tidbits here as we go through. So the first question many of you are probably asking is, as the employer, do you have the right to require your employees to report back to work? Yes, you absolutely do, right? Many of them were notified they were just being temporarily laid off or furloughed, but once you're given the authorization to reopen, it's business as usual. However, I've been calling it business as unusual. But you just need to make sure that you're going to have the necessary safety measures in place that we're going to go through here in this webinar, and that you're looking at doing it in a safe manner and the proper manner. And you as an employer, you need to have your workforce ready, willing, and able to come back to work and as needed. Those employees who are on unemployment right now, many are saying, I don't want to return to work because I'm getting more on unemployment, or I'd rather be, unemployed. Well, when they make that decision, that's their decision to make, but they're probably going to be forfeiting their unemployment benefits, and that's a risk that they may be taking. I can never give you a definite definite decision on unemployment because it could go either way, but generally, if you're not willing, able, and ready to return to work, and you get a job offer to return and you turn it down, you don't deserve unemployment. So that's something to keep in mind. Next slide. Okay, so phasing in your workers. Here's what we're going to talk about. So CDC recommends that you remain closed until you can implement these safeguards to combat the spread of COVID-19. That's the biggest thing, is to keep it from spreading. So there are healthy hygiene practices that they're requiring, intensified cleaning, disinfecting, and ventilation. Social distancing still needs to be taking place. Teleworking if you still can. Canceling any non-essential travel. If you're a business that has people who are traveling, if you still can be doing Zoom meetings and the like, they're still asking you to do that. If you can still telework and do your job from teleworking, they're asking you to still do that. Keeping your seating and your distance at least 6 feet apart. That's a big deal. Marking off in your conference rooms every other seat, or if people need to be in line somewhere, marking off 6 feet, closing down, or again, marking off and having procedures in place for break rooms. You can't have people huddling around the water cooler anymore. Staggering closing and starting times. Okay, that can help. Starting your shifts at different intervals, so you're not having all employees there at once. Restricting the use of any shared items or spaces, like I had mentioned, with the conference rooms and the break rooms. And the main important thing, too, is training all your staff on safety issues. Letting them know that you have got sanitizers all around the office or the workplace for them to use. Letting them know the proper protocol for walking down the hallway. Having their mask on in any public space. Or conference room or kitchen or whatever it might be. So those you want to make sure you have in place. Next. Okay, so let's talk about PPE. OSHA may require it. OSHA is talking about if the workplace is or is likely to be exposed of COVID-19, then employer is required to equip its employees with PPE. Many of your states are requiring it in their executive orders that the employer has to provide the PPE. So if you don't know if it's required that you as an employer need to be providing it to your employees, you need to talk to counsel and make sure, because every state's different. So, this PPE is going to be required wherever it is necessary by reason of hazards of processes or environment. So you need to make sure that you are keeping this in mind when you're reopening. Do you have enough PPE for your employees? You can ask employees to bring their own and give them guidelines on how to properly care for it and laundering it and things like that, but do you have some on hand for the employees who don't have it? The ADA may also be implicated. Employees may be asking for an accommodation because they can't wear a mask, okay, for a disability. You need to enter into that interactive process to determine out if there's a reasonable accommodation that you can give for that. Somebody may be asking for a religious belief accommodation. So you got to enter into the interactive process for that. So something to keep in mind when you're going to be reopening. Public transportation is a big thing. Many of the employees don't want to return to the office or don't want to return to work because they don't want to do share rides. They don't want to take the subway or the L or any type of public transportation or bus. Okay, this could interfere with their willingness to want to return to work. So as an employer, we got to be creative. We've got to pivot. Can you look at contacting your local garage to see if they will give you a discount for employees to be able to drive their own cars? Many of these public garages have been empty. So they're probably willing to, definitely give your employees a discount to be able to come park there and drive their own cars. So again, being able to pivot here and being creative is going to be important. You can, again, consider scheduling, being flexible to allow workers to use public transportation off-peak hours instead of during rush time. Okay, that's another way that you can look at it, and staggering their start and end times for their shifts. Carpooling, I highly recommend you discourage that or prohibit carpooling. Why? I can tell you that I've already dealt with a number of situations where an employee has tested positive and has been carpooling with employees. So right then and there, those carpool employees could definitely be susceptible to contacting COVID-19 through this one employee. So carpooling is not a good idea, but I definitely think being creative with parking garages and getting your employees safely to work is something you should consider.
Okay, the next thing we want to talk about is the child care issues for returning employees, because obviously that's another big deal, more so than usual. Because even after, workplaces are allowed to reopen, it's possible that employees are still going to have children at home, especially, now the schools are not reopening, except I think I heard one state out west is maybe having a limited reopening of schools, but everywhere else they're closed, child cares are closed, and even summer camps are being canceled. So employers need to be prepared to respond to requests from those employees. They might want to continue working from home, and as Heather said, the government is still encouraging that, that any employee who can work from home still, the government would actually prefer people to be doing that. But it may be that the employee, if they can't work from home, consider allowing that employee to take a leave of absence in order to care for, the children. Now, if an employee refuses to return to work due to a child care or other COVID-19 related issue, that person may be eligible for unemployment benefits under the CARES Act. And that act expanded eligibility to people who in the past wouldn't have qualified for unemployment. And that includes those with primary caregiving responsibilities for children who can't attend school or don't have child care. It also extends to care for those who have been diagnosed with COVID-19, household members, or the individual themselves, the employee, him or herself, who has a diagnosis. Next slide. So, and one thing to bear in mind, there are some daycare facilities that have been open because they've been authorized to, at least I know here in Indiana, they've been authorized to provide care for children of, critical workers, first responders. But just because some daycare facilities are open does not mean that the employee's daycare facility is open. And if your employee usually sends their child to ABC daycare, and if ABC daycare is still closed, that's when the Families First leave law kicks in. And so that's something to pay attention to, because the employee isn't required to send their kid to some, unknown child care place just because it happens to be open. Then as more businesses reopen, the good news is that there should be more child care alternatives available, but right now they are limited. So the responsibility to secure child care ultimately falls on the employee, and although you as the employer can alter the return to work date to allow the employee to secure child care while school is out, again, you're going to be wanting your employees to return to work. And you are perfectly entitled to, require them to return to work as those child care alternatives are in place, and especially, as they come back into play, regardless of the COVID-19 situation. Next slide. So much like addressing transportation needs, other issues related to COVID-19, you're going to be faced with the challenge of maybe creating shifts or alternating schedules to accommodate these, remote issues and to allow for childcare while ensuring that your business needs are met. Some businesses have staggered return dates depending on the job position to minimize exposure to each other, employees' exposure to each other, and to allow employees that time to arrange for childcare. So another topic is checking employee and visitor temperatures. I mean, this is something that usually we aren't thinking about talking about, but COVID-19 has definitely made that a practice that is now occurring in most businesses and most workplaces, in a lot of businesses and workplaces. So the EEOC is actually permitting temperature and symptom checks of employees for the COVID-19 pandemic. Some localities and states have actually required those types of screenings. One thing that we've been recommending, and again, some states are requiring this, is that you consider using a questionnaire or checklist for each employee who enters the work site, and this would extend to visitors too, and some of you actually may have seen this already, a questionnaire or checklist asking about the specific COVID-19 symptoms. If you're in Illinois, such a questionnaire or checklist is actually part of the guidance that the state issued for the phase 3 reopening. So the temperature checks follow the ADA requirements that mandatory employee medical testing has to be job-related and consistent with business necessity. In this situation, the reason why the ADA authorizes these checks is because the ADA recognizes that any employee who's infected with COVID-19 who enters the workplace actually poses a direct threat to others' health. So that's why those checks may be done at this point in time. So employers, if you're going to do these screenings and temperature checks, you should notify your employees that you're going to do that in advance. Inform the employees that the purpose of the screening is solely to protect them by keeping individuals with symptoms consistent with COVID-19 off-site, and not to determine if that employee has any other illness, impairment, or disability. So this is all, limited to the COVID-19 inquiries. And messaging should make clear that screening is not intended to be, nor is it a substitute for a clinical diagnosis. So you aren't diagnosing your employees or visitors, you're just checking to see if they have the symptoms, and then you're recommending that they seek medical care. And actually, at the end of this presentation, we have some great kind of sample guidance and actually something that you could post for employees to outline steps you might be taking. Next slide. So as I've indicated, the guidance that allows temperature checks right now is specific to the COVID-19 pandemic conditions, kind of the current conditions, and it may change if there are more effective COVID-19 prevention and treatment options that are discovered, and if the level of threat to the population abates. I mean, the CDC and actually the EEOC have both been issuing updated guidance as this pandemic evolves, and we expect that to continue. And then you've got states and localities on top of that issuing their own guidance. So it's very important to keep on top of all of that. So when conducting these screenings, you need to take into consideration how potential requests to be excused from a testing requirement for medical or faith-based reasons might be handled. And you've got to, when you're thinking about the threat to health and safety, there's got to be some pretty stringent requirements in the request to be excused have to have a really good basis for you to consider granting those. Then you need to ensure that you've got the equipment, personnel, and protocols in place to implement any checks that you're going to have. And then you've got to make sure those, the checklist, the systems, the protocols respond properly to any signs of illness. So, of course, it's, might be easy to talk about, oh, yeah, let's just start doing some temperature checks and, symptom screening, but obviously there's some logistical and administrative considerations. You need to think about where the screening is going to be conducted, and if it's done on site, how you're going to maintain social distancing for employees waiting to be screened, as well as those who might be required to leave the screening site without entering the workplace because, they have symptoms. You might, and as Heather mentioned, this gets back to the concept of staggering shifts, quite frankly, so you're limiting the number of people who are entering the workplace at any given moment, and so it would make it possible to, to have social distancing maintained while people are waiting to be screened. Other things to think about are, whether screening's done, people stay in their cars, you have them wait in their cars, those types of things. So in conducting the screenings, too, you should consider whether to use a current employee or an outside vendor to conduct the screening, regardless of who it is. The strict confidentiality of all of the information that's obtained from the employees has to be preserved. And in terms of thinking about an outside vendor, we know that some employers have tried to find outside vendors to perform these screenings, and they're in high demand. So there may not really be a third party available to do this, and you may need to train current employees to do it. As we mentioned, visitor and vendor screening is something to think about if visitors are necessary on site to support the workforce return to the workplace, or if it's just part of your normal business that that visitors and vendors are there. So you might think about at least having a questionnaire presented to them regarding their symptoms. And if any of you have ventured out recently, as I said, that some people do this by posting signs saying, do not enter if you've had signs, if you've had any of these symptoms. Others are actually, asking if people have had any of the specific symptoms, so there are different ways to approach it. Next slide. So if you decide to take employees' temperatures, obviously that's creating closer contact between the individual who's taking the temperature and the employee who could potentially be infected with COVID-19. So to protect the person who's taking the temperature, you need to evaluate the safety and health hazards that might exist and assess the risk to that individual. The safest thing to do would be to assume that the testers are going to be exposed to someone who's infected, who may cough or sneeze during the interaction. And then based on that anticipated exposure, you need to determine what efforts you can take to protect the employee who's taking the temperature by minimizing that hazard, and that would include considering PPE. And as one of the earlier slides indicated, a simple face mask, a cloth face covering, that is not PPE. Something to think about is that different types of devices can take temperature without being exposed to bodily fluids. The scanners, temperature scanners are something that a lot of folks are trying to use, whether they're the forehead scanners. The other thing is infrared cameras. What you do depends on the size of your shop and your capabilities, obviously. But the person who's taking the temperature should, at a minimum, wear a gown, mask, and gloves. They could have a face shield, too, in case someone coughs or sneezes on them. And then the other thing that's really important is make sure that the person who's conducting these checks can practice proper hand hygiene. So making sure, if there's not water and soap nearby, that there's plenty of the hand sanitizer, the alcohol-based hand sanitizer. It's got to be at least 70% alcohol. Next slide. So some more, I already talked about the social distancing a bit. Again, you've got to make sure that if there's going to be a line, we'll try to not have a line form that's actual people standing in line. That you've got to try to have social distancing. Think about tents or a temporary structure if you've potentially got a large number of employees who might be waiting. Think about the fact that this could somehow disrupt your normal production activities if you've got a long wait. And, the other thing to think about is privacy. That's why sometimes we talk about if you can, sometimes it's ideal to have the employees just waiting in their cars, and have these checks done while they're in the car, because then there's not as much risk, number one, of exposure, and number two, it creates a bit more privacy. But you've got to make sure that there is privacy where the screening takes place and where the results are announced, so that, other employees aren't overhearing what's going on. Next slide. So if an employee has symptoms of COVID-19, so this isn't someone who's diagnosed, but they've got symptoms, so you've implemented a screening, and the person has symptoms, or the other thing is that you've got to be monitoring people you should be monitoring people during the day. In Illinois, you actually have to perform these screenings, and you have to do it twice a day. Even if you're not in Illinois, you really ought to be keeping an eye on your employees. So if someone has symptoms of COVID-19, that employee should be told to leave work immediately and to seek medical attention. And you should not allow the employee to return to work until they've been symptom-free without using any medication for 72 hours and 10 days have passed since their symptoms started, or a medical professional has certified that the worker does not have COVID-19. And that guidance is based on, that's the current CDC standard. So if an employee tests or is presumed positive for COVID-19, even if they're asymptomatic, the local health department is likely going to tell you when that employee can return to work. And it's usually about 14 days, but it obviously depends. And generally it would require the employee to have a couple of a couple of negative tests before they can return. But that, once you have someone who actually has tested positive, it's most likely that the local health department who is going to be contacting you and telling you what steps need to be taken.
What employees are starting to sue now, stating that they need to be compensated for that time. So again, make sure you have the least amount of time to have them stand in line. Under federal law, that probably doesn't need to require paying for the temperature and system checks. However, many of the states that you're in are going to require it. So Illinois and Wisconsin, for example, your employees are likely going to need to be paid and compensated for the time they're in line. Somewhere like Indiana, Ohio, or Missouri, for example, under the current case law and statutes, it's likely not. But you need to check wherever you've got employees and you're taking temperatures. So the time that's going to need to be compensated for is the time they wait to get screened, taking the screen, and if applicable, waiting for the results before they start working. So that's something just to keep in mind if you're going to be going ahead and taking temperatures. Next. So let's talk about, protecting the health and privacy during the screening. I know Susanna touched on this, but you need to make sure that you're keeping these results confidential. Okay, you're keeping them separate from the employee's regular personnel file. You're keeping it in a separate confidential medical file. You do not want to share employees' names with other employees who may have been exposed. I know a lot of the places that, you work at, everyone knows when someone is the one diagnosed with COVID, but as the employer, you do not mention that employee's name, okay? You inform the employees that they may have been exposed and had exposure to someone with COVID, but you never release the employee's name as the employer, okay? So you keep this information with your screening as long as you need it, but when it's no longer needed, you need to destroy it. There's no reason keeping this medical information around if it's not going to be beneficial or needed anymore. Next. Okay, so does HIPAA apply? That's been a big question we've been getting from a lot of our employers when you're dealing with these temperature and symptom screenings. Not likely. Of course, if you're a hospital or something like that, you've got different restrictions, but for just general employers, you're not dealing with identifiable health information. And but you still want to be careful, okay? You're just a general employer, even though you're not covered under HIPAA, like in this situation, you still need to make sure you're taking these precautions and confidentialities. So any disclosures about someone having COVID or temperature checks or screening should really only be kept to the main people who need to know. You may need to let the government know if someone has COVID, and that's fine because, they're authorized, your local public health department's authorized to obtain this information regarding employees as part of their infectious disease control responsibilities, so that's okay. But again, you just want to make sure that you're containing it. And it's not, these temperature checks or symptom checks are not information's not, laying out in the break room or kitchen or on your desk out in the open. So you need to be careful. Do privacy rights apply? Not likely, but it depends on the technology you're using. So, under Illinois law, we've got the BIPA. Now, while I don't think a temperature check is going to be considered, something under BIPA, it's still, you don't want to be careless with this information and exploiting it or having it on the internet or something like that. You just need to be careful. Next. One thing that has arisen during this COVID-19 is discrimination. And employers need to be careful that you're implementing policies, procedures, protocols, that don't single out employees based upon any, protected characteristic, especially regarding their national origin or ethnicity. We've had a lot of situations where, employees are assuming that somebody, because they're of Asian descent or are Chinese, they automatically have COVID. So you need to be careful and train your supervisors to be on the lookout of any of employees who may be treating others this way and essentially discriminating against them so that you can nip it in the bud and deter it from happening. Next. So again, just making sure that your managers, supervisors are trained to be on the lookout for this, because there are people out there who are improperly assuming that because someone is of Asian descent or Chinese, that they're automatically having the COVID. So the xenophobia is a huge backlash against these groups, and it shouldn't be that way. And you don't want to be on the news regarding your employees who may be discriminating against others. So make it clear in your communications and in your policies to employees that this type of behavior is not going to be tolerated and appropriate discipline action will be taken. Next. So, a big question we've gotten is, is fear alone of getting COVID protected action, and which you need to be careful about, are retaliation concerns to keep in mind. Fear alone is generally not protected. Someone who refuses to work because of fear is really abandoning their job, as I mentioned earlier. And however, employees need to only have a good faith belief that their workplace is not safe. So if you're going to be terminating a worker for voicing their genuine concerns of safety, you need to be avoiding that. New statutes are coming out daily, weekly, with regards to, you can't retaliate against an employee because they had COVID or they're taking care of a family member or things like that. So the best thing to do is to do counseling, educating, coaching your employees on their fears and what steps you're taking with disinfecting and having hand sanitizer and social distancing and requiring PPE and things like that. That education, counseling, and training will go a long way. You need to be careful. Someone may have anxiety or depression. This could trigger a disability protection under the ADA or your local state disability laws. So again, if you've got someone who's got, that type of disability, you're going to have to enter into the interactive process. At the end of the day, it may mean the employee can't return to work safely with a reasonable accommodation, but you need to show you tried. And you worked with the employee, you worked with their doctor to see if there's a reasonable accommodation to alleviate that fear or whatever it might be. Next.
So what do you do if an employee ends up coming into contact with someone at work who is diagnosed with COVID-19? So contact tracing has become a big deal. And that is something that you've probably heard about this in the news, but the health departments, local health departments are taking on this responsibility. And as I said earlier, if you end up having an employee who tests positive for COVID-19, you're most likely going to be hearing from the local health department, and what they are probably going to be doing is to notifying you, number one, that the one specific employee tested positive for COVID-19 and is going to be off work for a certain amount of time. And then number two, they will probably either provide you with a list of employee names who the sick employee told the health department that sick employee was in close contact with during the, it's usually within the 14 days surrounding the diagnosis or just before the diagnosis. Or the health department may ask you for a list of your employees. The other thing, the health department may ask for contact information for the employees identified by the sick employee. And I will tell you that the health departments have broad authority when it comes to contact tracing. And so generally speaking, although you may want to, if you get an odd request, you may want to contact your attorney to make sure. But generally speaking, the health department is entitled to the information they're requesting. So there is a big distinction between close contact and no close contact. So just because you have an employee test positive does not mean that every other employee of yours is a close contact of that employee. So if a close contact, number one, let's talk about what that means. It's generally someone who has been within 6 feet of the sick employee for a prolonged period of time. Now, that prolonged period of time, right now, there's some guidance saying that's 15 minutes. Not too long ago, it was 10 minutes. So we're saying 10 to 15 minutes. So if someone has been within 6 feet of the sick person for 10 to 15 minutes, not wearing PPE, they generally are going to be considered a close contact of the sick employee. And it's those close contacts who have to be notified that they were indeed in close contact with someone who has tested positive for COVID-19. And those individuals are the ones who, be it from the health department or from you, but those individuals will be instructed to stay home, generally speaking, for 14 days and to monitor themselves for symptoms, and if they develop any symptoms, to seek medical attention. Employees who were not in close contact, so who do not fall within that being within 6 feet for 10 to 15 minutes, those individuals do not need to be told to leave the workplace. However, if they, everyone should be told that there has been a positive case and that they need to self-monitor for symptoms. I mean, that is a best practice, but the only individuals who are told to stay home are those close contacts. Everyone else should be self-monitoring anyway. Next slide. So if an employee is diagnosed, I touched on this a little bit, so for the employee who's diagnosed with COVID-19, you need to follow the local, state, and federal guidance that is in place at that time, determine what's the most cautious, conservative approach. Right now, the guidance is that the individual who tests positive is going to be out until they're symptom-free for at least 3 days without using any medication to alleviate those symptoms, and 10 days have passed from the first day symptoms started. And from the workers' comp perspective, what you need to be figuring out is if the employee contracted the virus in the workplace. Next. And Heather's going to talk to you about OSHA.
Okay, great. So I'm going to be moving a little bit quickly because I want to be respectful of your time. We're going to be talking about OSHA and workers' comp. Remember, you're going to get these slides. So a lot of what we're talking about, you're going to have right at your fingertips. So first with OSHA, they again revised their guidance. Okay, so previously we know from OSHA that they issued guidance that said most employers only had to record or report confirmed COVID-19 cases when provided with objective evidence that employee contacted COVID-19 at work. In practice, this put the burden on the employees to submit evidence that they contacted it at work. However, as of May 26th, OSHA revised and gave us new guidance on this issue. And OSHA now, of course, puts the burden on the employer to make a reasonable determination as to whether a confirmed COVID-19 case was actually, contracted at work. So in order to make the determination, here's what OSHA suggests for employers. Question the employee as to how he or she believes they contacted COVID-19. Discuss with the employee his or her out-of-work activities that may have resulted in exposure, and review the employee's work environment for the potential of COVID-19 exposure. And when we get to the workers' comp, we're going to go over a really great questionnaire and checklist for you that's really going to help you through this so that you can determine whether it was likely the employee got COVID from the workplace or not. Next. So then the guidance goes further to state that after you've taken those steps with the employee, and the only logical explanation is the employee contracted COVID at work, then the case should be reported to OSHA and recorded as appropriate. So moving forward, we recommend that you prepare a questionnaire to be filled out by the employees when they have a confirmed COVID-19 diagnosis, and have like an accident type of report. And I think the workers' comp questionnaire that we're going to go through is going to be really related to this and help you in your decision-making process if you think the employee actually got the COVID at work and if you need to report it. Next. So let's talk about workers' comp. So, generally, You know, under most workers' comp laws, it's the employee's burden to establish that their injury or their illness was directly caused by their, you know, their work duties. However, some states are trying to create new rebuttable presumptions that a first responder or frontline worker or any type of worker, like we had going on in Illinois previously, who contacts COVID-19 is going to be covered by workers' comp. So what we recommend is you prepare a questionnaire for the employee who is diagnosed with COVID to determine that it was likely that they either got it from work or they didn't. You know, some employees out there are not social distancing, they're traveling and taking, you know, different risks. And you may have no COVID cases at work or no one with symptoms and things like that. You're going to want to try and parcel that out. Next. So we have a questionnaire for you. Look at this. How fun are we, right? So when you ever have to deal with the workers' comp investigation or to deal with OSHA compliance, we have created a questionnaire for you. Of course, it's going to need to be tailored to your company for sure, but this is going to give you a good overview of what to expect. You know, what is the date the employee first exhibited symptoms of COVID? What were those symptoms? And there's a checklist. Next. When were you diagnosed with COVID or presumed to have COVID? You know, did you test positive or were you just presumed positive? You know, many doctors are saying, I'm not going to test you for COVID because I'm going to treat you the same way. So the doctor may just presume it and not actually have a test. You know, which medical provider gave you the test? That's important. You know, when this first started, we had many employees lying about them having COVID and wanting to stay home, or because they were actually arrested and in jail but lied about having COVID. So we need to be careful, and as an employer, you're allowed to ask for this information. You know, go into what are your current symptoms. You know, looking at when they contacted it and first had symptoms to now, has it been, you know, 21 days, 28 days, or has it been 14 or 7? That's why we want to ask these questions. Next. You know, we want to know, did a doctor tell you that you need to self-quarantine? If so, for how long? You know, in the previous 30 days, I think this is going to be really important. Were you in close contact with somebody who was tested or diagnosed with COVID? Are they living with someone who tested positive for COVID or taking care of someone who tested positive? That could go against them getting it from the workplace. Another quick question is, you know, in the last 30 days, have you traveled or stopped in a country where the CDC has issued a travel health notice? China, Iran, Europe. That, again, is going to be another indicator that they possibly didn't get it at work. Next. You know, in the last 30 days, have you domestically traveled by an airplane, a bus, or a train? There's another way that they could have contacted it. In the last 30 days, were they using mass transit or any type of public transportation? Outside of work, have you attended an event where there were more than 10 individuals in attendance and you were not within, you know, that you were within 6 feet of those individuals for more than 10 minutes? If so, where? You know, then have them certify that their answers are correct, you know, and that they're telling you the truth. This is going to be the evidence you want to have when you're dealing with OSHA, when you're dealing with workers' comp, a third-party liability lawsuit, things like that. This is what you're going to want to have in your arsenal. Next. We also are going to be giving you a confidential checklist for you to have, so that you can have your investigation done at the same time that the employee is filling out their questionnaire. You know, this checklist is going to be, did you receive any paperwork from the employee regarding their diagnosis? Some employees aren't getting it, or return to work slips. Did you get any? Did you review any of their social media accounts? to see if they had any recent travel or social interaction. They may post a party about post a picture of themselves being at a party with 100 people or traveling internationally or something like that, and then they lied about it on their questionnaire. Now you're not terminating them because they filed a workers' comp claim or because they said they had COVID. It's because they lied to you on this documentation. So social media is an amazing thing. Everybody loves to share, so it's always good to be checking those. Another thing on your confidential checklist is, did you inform all of the employees' coworkers that they were in the close contact with somebody? That's another checklist item. Next. Prove up that you're taking the steps to clean and sanitize. Make sure you're disinfecting pursuant to your CDC and public health guidelines after someone has said they have COVID or have the symptoms, and make sure you're following those guidelines. Are you following CDC and OSHA guidelines about safety and health measures in your workplace, including all the PPE mandates? Sometimes this checklist is a reminder, oh shoot, we didn't do it, we need to do it. And then, have you implemented the latest guidelines or mandates from your public health department regarding, this area? Next. So just real quickly to recap, just some, our job as employment labor attorneys are to keep you out of trouble. So these are some things you should be thinking about. Are wage and hour issues, including timekeeping. You might be having hourly employees who are working, remotely. Are you capturing all of their time that they're working correctly? You want to make sure you're doing that. New leave laws. Are you up to snuff on the Families First, FFCRA, and giving out that and properly following those leave laws? FMLA, are you following FMLA and making sure? And one thing about the timekeeping issue I also wanted to make sure is, many of you are being creative in how you're furloughing employees. Are you doing that correctly? Make sure you're doing that so you're not running afoul of, the FLSA or any of your local state wage and hour laws. ADA, reasonable accommodations, we've already talked about that. Make sure you're entering into those interactive processes. WARN, did you follow WARN correctly? Are you coming up to 6 months of it being 6 months more or less for notice? Did you follow any, current notice WARN local laws? Are you following those? Those are different than the federal. And then lastly, the NLRA. As we just had a blog go out by Beverly in our group, a new symptom of COVID-19 are unions. They're active. Just because you don't have a union on your property right now and dealing with them right now doesn't mean they're not talking to your employees. Are you working in a safe environment? Are you being paid correctly? Are you getting your Families First, sick leave? Things like that. They're on the rise. Make sure your managers and supervisors are alerted and looking for this type of behavior and if it's happening and how they can properly react to it. Make sure they know that about the Families First and that they're administering it and putting them in contact with HR when someone talks about it to them. So again, just keep in mind, I always say plaintiffs and attorneys need to eat as well, and so they're on the ball. They're already filing lawsuits. The Families First already had a lawsuit filed on it. So just make sure you're up to snuff and you're in touch with your counsel on this. Lastly, public relations and media inquiries. This is coming up when you've tested positive, when you have an employee test positive. This is coming up. You might be bombarded with news anchors and the like. So just make sure that you communicate your protocols to employees, that you're taking all these measures to keep them safe, that they know this is the time to keep them, in the dark on what you're doing. Make sure that you're always reiterating that, safety is your #1 priority. Reiterate to your employees about, any type of public relations or media relations policy that you have. And then if you're getting these questions, you always just want to stress how you're committed to implementing the latest guidance with regards to CDC, OSHA, your public health department, the governor's office. You're attuned to that as an employer, and especially are today, right? All right, I've gotten the question many times. Can I have my employees sign a waiver that they can't sue us if they get COVID or anything like that? Not a good idea, right? Liability waivers for employees have traditionally been unenforceable because of unequal bargaining power between parties. Employees can't waive their workers' comp rights anyway, so it's really going to be a non-issue even if you do have these waivers. So again, it just creates the perception that you are not trying to be safe. You're not following CDC or OSHA guidelines. So I recommend that you don't do it, and it's going to be a negative reaction and morale with your employees and outside in the public. Next. And the waivers for customers. We've looked into it. The main thing I can tell you here is you need to know your state law because it's going to be different everywhere. It could be used as an effective deterrent to have your employees sign a waiver, your customers sign a waiver. But you need to make sure that it's valid and enforceable. So you need to look at it not being contrary to your local public policy. You can't waive any intentional or reckless or gross negligent conduct. You know, if you've got all of your employees not wearing masks, you're probably going to lose, that waiver if a customer goes to sue you. It's got to be clear. It's got to be unambiguous. And it's got to be flexible. So make sure you know your states if you're going to be looking into doing a waiver for your customers to sign. Next. All right,
so
Susanna.
as I mentioned earlier, this kind of falls along some other, samples we've been giving you, but, this would be some reopening guidance that you might post, as I mentioned earlier, for your employees to let them know what steps you are taking as part of this reopening process. So this is actually, and we can go through this pretty quickly because we covered a lot of it, but this lays out first, this is for a business that is going to do employee symptom monitoring, and it lays out that employees have to monitor themselves. It lays out, screenings. It lays out what, that if an employee develops symptoms, they have to notify their supervisor, and then how long the employee has to be off work. Next slide. And then it talks about the steps to be taken if an employee tests positive or presumed to have COVID-19, and then what happens with them and their close contacts. Next slide. And then it also talks about steps, being taken in the office, wearing face masks, washing hands, the types of things that most businesses started back in March. Next slide. And then continued changes, in the office, addressing cleaning protocols, what are you doing with the coffee maker, the water cooler, the break room, visitors, meetings. Next slide. And then finally, travel restrictions. A lot of companies, that maybe had travel or restricting travel. So that's another area to consider. But these last few slides, the idea is that this is the type of thing that you could adopt as a memo that you might post or distribute to your employees, and you don't to announce what it is you're implementing in response as part of the business reopening plan. Next. And that's,
okay.
Go ahead, Heather.
Sure, okay. So just remember that everything's changing. So just make sure you're getting the most updated guidance. We have an amazing resource here with our COVID-19 task force. So we give you the website. We have our blog. We're blogging on this weekly. So make sure you're signed up for our blog. And then I'd like to put up the next slide with Susanna's and my contact information. If you have any questions and want to follow up, here's our emails, here's our phone numbers. Give us a call. Remember, you're going to be getting these slides so that you can go ahead and review them at your leisure, but then definitely use them when you're going through this, because this isn't an easy time for everyone. So make sure you reach out to us with any follow-up questions that you might have. We had a lot to cover today, so thanks for your patience.